Hi, hello, namaste. I am Srijit Mitra, a BLLB third year student at Manikchand Pahare Law College, Maharashtra, currently interning at Lawsymptoms. I welcome you all to the Lawsymptoms. In this presentation, I will be dealing with a very fundamental topic of the trademark, that is the opposition proceedings under trademark law. So before I start with this presentation, let me just give you an overview of this presentation. First, we will see in this presentation what trademark is. Then after we will see the trademark advertisement. And then finally we will see the opposition to registration, under which we will cover notice of opposition, counter statement, evidence, affidavits, translations, hearing and decision, and so many uh, important topics. So without any further ado, let's get started with our first topic, that is trademark. Trademark. In simple words to describe it, a trademark is an easily recognizable symbol, phrase, or word that denotes a specific product. A trademark can be anything, including a name or logo, if it distinguishes the applicant's good or services. We get the definition in section 2ZB in Trademark Act 1999. For example, a trademark is an word, say for example, Pepsi, Coca-Cola, uh, a surname like Tata, Bata, signature, Louis Philippe, etc. So, moving with our the next topic, that is the trademark advertisement, which comes under the Rule 41. Imagine you have a special symbol or name of your favorite toy. Let's call it Super Robot. If you want to make sure that no one else can use the name or the symbol for their toys, you can apply for a trademark under Rule 41. It takes it likes telling anyone, hey, this is mine, and no one else can use it for their toys. So when people see the name of your toy, a symbol, the super robot, they know it belongs to you and not to someone else. It's like having a special stamp that says, this is mine, hands off. This is trademark advertisement. Rule 41 governs the process of trademark registration, which involves advertising the trademark to the public. Think of a trademark as a distinctive logo, symbol, or name associated with a product or service. When you want a legal protection for your trademark, you file an application under Rule 41. Advertisement takes place in the Trademark Journal, which is released every Monday weekly, and it's very systematic. And the form TMM, the trademark, TM means trademark, form TMM according to Rule 41 is used to request the advertisement from the registrar. Now I will show you the form TMM here, which I have collected from the official website of Government of India Intellectual Property. Uh, this is how form TMM looks like, and then after without any wasting any time, let's just give a dive into the main topic of our today's discussion of the presentation, that is the opposition to registration of the trademark. The section 21 reads with the rule 42 to 51. uh, Now in this, we will show a flow chart first. In this, a timeline, basically a timeline is given of every procedures, like notice of opposition, the counter statement, evidence in support of opposition, and so on and so on. So we will discuss each and every topic from here in details. In the rule 42, we will deal with the notice of opposition, where you will see, like, imagine you have a very favorite toy, let's call it Super Robot. Now you imagine someone else tries to say that name belongs to their toy. A notice of opposition is like a way of saying, hey, that's not right. Super Robot is mine. It is a formal letter you send to tell everyone, especially the people in charge, that you don't want someone else using the name or the logo of your favorite toy because it's your special. It's like raising your hand and saying, I object. So everyone says the super robot is yours. Basically, a notice of opposition is a formal legal document used in the context of the trademark proceedings. When someone opposes the registration of a trademark, they file this notice with the relevant authority indicating their objection to proposed trademark registration. It typically outlines the grounds of opposition, such as similarity to an existing trademark or potential confusion in the marketplace. Uh, upon Within the 4 months after the publication of the advertisement of the mark in the trademarks journal, any person can oppose the mark by filing a notice of opposition on the prescribed form TMO. TM stands for the trademark here, along with a prescribed fee of rupees 2,700. Where a notice of opposition has been filed in respect of a single trademark, however, for different classes of goods and services, it shall incur the fee in respect of each class to which the opposition is filed. Now, upon receiving the notice of opposition, the applicant has the chance to respond, often by filing a counter statement. So we will discuss about the counter statement in our next slide. So before I discuss with the counter statement, I would like to show the form TMO. This looks like, and similarly I have collected this from the official website of the Intellectual Property Government of India, and this is how it looks like. Now moving with the counter statement, which comes under the rule 44, rule 44 of the trademark rules 2017. It says that within 2 months after receiving the notice of objection or opposition, notice of opposition, the applicant must file a counter statement or reply to it by using the form TMO and pay the prescribed cost of rupees 2,700. The cost must be paid for each class to which a counter statement is being filed, even for the counter statements. Upon being receiving the notice of opposition, the applicant has a chance to respond, often by the filing a counter statement. The opposing party then has a specific period, usually 2 months, to submit the substanting evidence in the form of the affidavit under Rule 45, which we will cover in our next slides. This evidence, including exhibits, is provided to support the opposition claims. Alternatively, the opposing party can choose not to submit the affidavit and rely solely on the facts stated in the original notice of opposition. Failure to present evidentiary support or submit a waiver within the specified time frame results in the opposition being considered abandoned. This process ensures a systematic and fair resolution of trademark disputes, taking into account legal protocols and timelines. Now moving with our the next topic of discussion, that is the evidence in support of opposition, which comes under the rule 45 of trademark rules 2017. Here we see that the opposing party has 2 months following the receipt of the counter statement to present the supporting evidence through an affidavit under the rule 45. This evidence, along with the exhibits, must be submitted to the register and a copy shared with the applicant. Alternatively, the opposing party can choose not to submit the affidavit, relying solely on the facts in the notice of opposition. However, this decision must be communicated in writing to both the registrar and the applicant within the specified time frame. Failure to provide evidence or submit a waiver within the 2 months period results in the abandonment of the opposition. Now, in Rule 46, the evidence in support of application within 2 months of receiving the affidavit and evidence under Rule 45 or a notice indicating the opposing party's renunciation, the petitioner must present supporting evidence for their trademark application. This involves the submitting an affidavit as per Rule 46 along with duplicates of evidence and exhibits to the registrar and sharing a corresponding copy with the adversary. Alternatively, the petitioner can choose not to submit the affidavit, relying on the facts in the counter statement or previously provided evidence. This decision must be communicated in writing to both the registrar and the opposing party within the specified time frame. Failure to provide the evidentiary support or a waiver within the 2 months leads to the automatic presumption of the trademark application abandonment. Now moving with the Rule 47, evidence in reply by the opponent. The evidence in reply by the opponent phase occurs after receiving the applicant's evidence, typically in the form of an affidavit, and substantiating evidence under Rule 45. The opposing party has a month of period to provide their own evidence, often in the form of an affidavit, according to the Rule 46, countering the applicant's claim. This evidence, along with the exhibits, is submitted to the register and a copy is sent to the applicant. Alternatively, the opponent can choose not to submit the additional evidence and rely on the previously presented facts. The strength of this evidence plays a crucial role in determining the outcome of the trademark application dispute. Failure to present the evidence or a waiver within the specified time frame results in the automatic presumption of the abandonment of the opposition. Now moving to the next slide, we will see Rule 48 and 49, further evidence and translation of documents. Here in the further evidence, no further evidence shall be left on the either side. But if the registrar thinks fit, he may give leave to the applicant or opponent to produce any evidence upon such terms or costs. And in the translation of the documents, if any document referred in the opposition notice, counter statement, affidavit is in a language other than English or Hindi, a translated copy of the same shall be produced to the registrar and the other party. And now, if we move to the Rule 50 of the Trademark Rule 2017, it involves with the hearing and the decision in the trademark proceedings. After both parties submit evidence and argument, a formal hearing is conducted. The registrar or the designated authority reviews the information presented and makes a decision on the trademark application. This decision could include approval, rejection, or other outcomes based on the merits of the cases. Now moving to the next slide, the security of the costs, the last rule in opposition to registration, Rule 51, security of the costs. We see that the security for the costs which registrar may require under subsection 6 of the section 21 require may be fixed at any amount which he may consider proper, and such amount may be further enhanced by him at any stage in the opposition proceedings. Now, to finally conclude, when the registrar decides in favor of the applicant, the trademark will be registered and will issue the trademark registration certificate. And when the registrar decides in favor of the opposing party, then the trademark registration application will be rejected. As we conclude our presentation today, I want to emphasize the key takeaways and the significance of the information shared. In today's discussion, we delved into the opposition proceedings under trademark law in India. We explored trademark law, trademark we explore trademark advertisement, opposition to registration, notice of opposition, counter statement, affidavits, and so on, so on. So I hope that the presentation provided valuable insights into the opposition proceedings under trademark law in India and has sparked thoughts and discussions. So thank you for your kind attention and engagement throughout this presentation. If you have any questions or query, please feel free to ask. We appreciate your time and look forward for future discussions on the related topic. Thank you.